Hey guys, on this side. Uh, this is the video about the second law case which I took for the law CIA given by Chirag sir. And this case name is Veneetha Sharma versus Rakesh Sharma. This case is related to the Hindu Succession Act of 1956, right? So, what is Hindu Succession Act of 1956? It is the legal right of all the sons and daughters to get the ancestral property of their parents, right? And then came the amendment of in 2005 for this law act. Then came all the problems related to this act, which led to Veneetha Sharma versus Rakesh. So, what was the Amendment Act of 2005 states? That states that before 2005, there was no legal right for women to get the property, right? After the amendment of 2005, women also get the equal right as their brother to get their equal right in their ancestral property. This was the amendment came in 2005. Basically, this law applies for Hindus, which means all the Hindus, and this includes the Buddhists, the Sikhs, the Jains, and all. Right? This law is applied for both for everyone. Right? All the Hindus. So now we'll talk about the case, which is Veneetha Sharma versus Rakesh Sharma. But before going to that, but actually we have three cases. Actually, total we have three cases, which leads to Veneetha Sharma versus Rakesh Sharma to the final result. But there was an issue. The issue was issue with the 2005 amendment was the issue was the problem. This amendment was active on 9/9/2005. So before 9/9 to 2005, if the father is dead, so if he gets the, which means property of the daughter, property of the father should be passed down to the daughter if he's alive before 9/9/2005. So this was said that the father should be alive before, right? So in that we'll see in the case one, which is Prakash versus Pulvati in 2016. The judges were Judge Anil Dave, Judge A.K. Goyal. These were the two judges which were there, right? So in this case, it was said that the living co-penser should be alive, which means the father should be alive. Then only the living daughter will get the property. All right, in this case. But in after 2 years, in the case two, in the case of Dhanamma versus Amar in 2018, which is after 2 years, there was two judges. There were Judge A.K. Shastri and A.K. Judges Ashok Bhawan. This said that if father is even dead before 2005, which is his father, which is her father was dead in 2001, then also the right will be passed to a daughter. All right. Then comes our main important case, that is the case 3, Veneetha Sharma versus Rakesh Sharma in 2020, and there were three judges in this. The Judge Arun Mishra, Judge S. Abdul Nazar, and Mr. M.R. Shah. Right. Then in this, Supreme Court simply said that the right to the woman will come when she is born. Right. Woman right to be right to ancestral property is by birth, and if the father is not alive or not, that will not make any difference. It is equally transferred even if the father is dead. So this is the case of Veneetha Sharma versus Rakesh. This I'll be making it clear by reading this, right? So the issues before the Supreme Court in this case is whether the amendment section 6 of the Act 2005 requires the compenser to be alive as on 9/9/2020, right? Which was for the daughter to claim right in the compulsory property. Whether the amendments of section 6 of Act 2005 prospect the respective of the radioactive. And then the arguments advanced on behalf of the Union of India by Solicitor General of India. All right. The Amendment Act of 2005 is not retroactive but retroactive in nature. Confrontant of right on daughter did not disturb the right which was civilized in the partition before 2012-2004. The daughter of the compensor in section 6 does not imply daughter of living compensor. The compensor need not to be alive as on the date of commencement of the Amendment Act. The explanation of section 6 of 5 as regards requirement the registered partition deed is directory in nature and not mandatory. The arguments advanced by learned senior colonel and amical Mr. R. Venkataraman. There is no conflict between the decisions of Pulvati and Dhanamma, and in both the decisions, the provisions of Section 6 have been held as proactive in nature. On the death of Compensor, his interest would have merged with the surviving compensity, and hence, when the death of Compensor father, that is the father, there will be no surviving compensor for whom the daughter will succeed. Therefore, the daughter can succeed only in the interest of living compensor. Although the equality has been brought in the effect of 2005 amendment, the incidence of birth of compensor before 2005 is not considered. Oral partition of family settlement are not intended in the reopen of section 6 of 1 and section 5. And then arguments advanced by learned senior Mr. V.S.S. Rao. Logic of a decision in Pulvati and is upheld by Mamangal versus T.B. Raju and others. Alright, they were. A daughter born before 2005 is considered as compensor. By the language used by section 6 of 1, B and C, the parliament intended to mean conferring the rights of the compensatory prior to the amendment and not the effector. As per the prevailing law, it was not necessary that the partition should be registered. In this case, which are oral partition and recognized, it should be backed by proper evidentiary report. The parliament did not intend to confer a daughter with the rights of the compensatory property and radioactivity. So, the use of words on and from in section 6 indicates that the daughter becomes compensor from compensor of the act. The status of compensor referred to the daughter cannot affect the past transaction of alliance and deposition and partition orally or written. The explanation safeguards all the genuine transactions of the party, including all oral patterns affected by the parties. Then there should be a living compensor whom the daughter can inherit to become a compensor. Right. Then the arguments advanced by advocate Mr. Amit Pai. The situation of section 6 under the Amendment Act dates back the commencement of Principal Act of 1956, which was before the national partition of the death of the compensor and ascertain his shares is not an actual partition, and same is not excluded in previous contained in section 6. Decision in Pulvati cannot be said lying down and correct law. The concept of living daughter of living compensor is adding to the text of the provisions of section 6. Section 6 includes all daughter whether the father is alive or alive as on date of amendment of the Act. So what is the conclusion? That is the judgment. Among others, issues answered by Honorable Supreme Court in the above case, following are answered. The right conferred on the daughter in the compensatory property is by birth, and hence it is not necessary that the father be alive on 9/9/2005, which the amendment was passed. As such, the decision in Pulvati case is overruled and the decision of Dhanamma case is partially overruled to the effect where it said that the compensor father has to be alive on 9/9/2005. The amendment by way substitution of section 6 of Act 2005 is radioactive in nature, which means even if the father is dead, then also the daughter will get the ancestral right of the property even if the father is dead before the 2005. So this is the conclusion of the case of Veneetha Sharma versus Rakesh Sharma. So thank you.